Hello and welcome to the Entrant. The topic for today's discussion is Article 13, Laws Inconsistent with Fundamental Rights. This topic holds great importance when it comes to questions asked in competitive exams. Before delving into the subject matter, let us familiarize ourselves as to what this article is. The Constitution of India has provided citizens of the Indian nation with certain basic rights, which are indispensable for maintaining a decent and humane standard of living. Enshrined in Part 3 of the Constitution, the fundamental rights have been considered to be of utmost importance for the people of the country. However, it is Article 13 which gives teeth to these fundamental rights by making them enforceable in a court of law. Therefore, Article 13 provides for judicial review of all legislation in India, past as well as future. This power has been conferred on the High Courts and the Supreme Court of India through Article 226 and Article 32, which can declare a law unconstitutional if it is inconsistent with any provision of Part 3 of the Constitution. The main objective of Article 13 is to secure the paramountcy of the Constitution, especially with regard to fundamental rights. Therefore, through this article, it has been made very clear that no other law can negate the supremacy of any of the fundamental rights of a citizen. If the law is found not to be in agreement with a right, it is the law which will have to be removed or amended adequately. Moving on, looking at the prospective nature of fundamental rights, Article 13, Clause 1 is prospective in nature, meaning all pre-constitution laws inconsistent with fundamental rights will become void only after the commencement of the Constitution. They are not void ab initio, meaning they are not invalid from the beginning. Such inconsistent laws is not wiped out so far as the past acts are concerned. A declaration of invalidity by the courts will, however, be necessary to make the laws invalid. The Supreme Court, in the case of Keshav Madhava Menon and State of Bombay, observed that Article 13, Clause 1 could not apply to that case since the offence was committed before the commencement of the Constitution and hence the proceeding against the appellant was strong. Now we will look at Clause 1 and 2 of Article 13. According to Clause 1 of the article, all pre-constitutional or existing laws, that is, laws which were in force immediately before the commencement of the Constitution, shall be void to the extent to which they are inconsistent with fundamental rights from the date of the commencement of the Constitution. Whereas Clause 2 of this article provides that the state shall not make any laws which takes away or abridges the fundamental rights conferred by Part 3 of the Constitution, and any law made in contravention of the fundamental rights shall, to the extent of the contravention, be void. Now, we will look at what the meaning of the expression "to the extent of such inconsistency" means. The words "to the extent of this contravention" in Clause 2 means that where a pre-constitutional law is in contravention with a fundamental right, only that portion of the law which is inconsistent with the said fundamental right shall be void. Clause 2 also states that the government shall not make a law in contravention of any of the fundamental rights, otherwise that law in question or only the inconsistent part will be declared as void. Therefore, the entire law will not be held void ab initio only on the basis of error found in some portion of the law. Meaning, it shall only be declared void only to the extent to which it is dissenting. There are three doctrines that we have to study under Article 13. The first one of them is doctrine of severability. When a part of the statute is declared unconstitutional, then a question arises whether the whole of the statute is to be declared void or only that part which is unconstitutional should be declared as such. To resolve this problem, the Supreme Court has devised the doctrine of severability or separability. This doctrine means that if an offending provision can be separated from that which is constitutional, then only that part which is offending is to be declared as void and not the entire statute. The Supreme Court, in the case of Motor General Traders versus State of Andhra Pradesh, summarized certain rules for determining how to separate valid parts from the invalid ones, which are as follows. The history of the legislation, its subject, its object, the title, the preamble to the statute must be determined to know the legislature's intention behind enacting such laws. This will clarify the need and importance of enacting such a law when it was enacted and whether it can be done away with or not. We also have to keep in mind that if the valid and invalid portion are so distinct and separate that after striking down what is invalid, what remains is in itself a complete code, independent of the rest, then only the statute will be upheld. Otherwise, will be said to be void. This doctrine, however, is subject to one exception. That is, if the valid portion is so closely mixed up with the invalid portion that it cannot be separated after leaving an incomplete or more or less mingled remainder, then the courts will hold the entire act void. This has been held through the case of Deepak Sibal versus Punjab University, where it transpired that if the valid and invalid portions are very intricately mixed up and are almost inseparable, then the invalidity of a certain portion will lead to striking down the complete law entirely. We also have to keep in mind that even when those provisions which are valid and distinct and separate from those which are invalid, if they all form part of a single scheme meant to be operated as a whole, then the invalidity of that part will result in failure of the whole provision. Another point to remember is if after removing the invalid portion, what is left of the law is so precarious and lacks any substance and cannot be enforced without making any alteration or amendments therein, then also the statute will be rejected in its entirety. Now that we've understood the doctrine of severability, let's look at doctrine of eclipse and waiver. The doctrine of eclipse is based on the principle that a law which violates fundamental rights is not nullity or void ab initio, but becomes only unenforceable. That means remains in a moribund condition. Now the question arises, can such a law which becomes unenforceable after the constitution came into force be revived and made effective again by an amendment? This was solved in the case of Bhikaji versus State of Madhya Pradesh, where through the Berar Motor Vehicles Amendment Act of 1947, the state government was authorized to have monopoly of the entire motor transport vehicles business in the province. However, in 1950, when the constitution came into force, this act violated the right to practice any profession which is enshrined in Article 19. But then again in 1951, when clause 6 was added to the Article 19 after an amendment which gave the right to the government to monopolize any business, the Supreme Court held that the effect of the amendment was to remove the shadow and to make the impugned act free from all blemish or infirmity. That means as soon as the eclipse is removed, the law begins to operate from the date of such removal. Another question arises, does the doctrine of eclipse apply to a post-constitutional law? In the case of Deep Chand versus State of UP, the Supreme Court held that a post-constitutional law made under Article 13, Clause 2, which contravenes a fundamental right, is nullity from its inception and is a stillborn law, which means it is void ab initio. Therefore, it is invalid from the beginning. The doctrine of eclipse does not apply to a post-constitutional law and therefore its subsequent constitutional amendment cannot revive it. Now we look at doctrine of waiver. Can a citizen waive his fundamental rights? As per this doctrine, an individual who has possession of certain rights or privileges can voluntarily give up the same or waive them. It is the voluntarily abandonment of the privilege, being fully aware of the consequences that will entail. But this doctrine is not applicable in India. With respect to whether fundamental rights can be waived by a person or not, the Supreme Court in Suraj Mali Mehta versus A.V. Vishwanath Sastry upheld that fundamental rights could not be waived. In the majority opinion, the law may be stated that doctrine of waiver or estoppel cannot be imported to whittle down the plenitude of the fundamental rights, and thus it has been propagated through the case of UQE Society versus Government of Andhra Pradesh that an individual cannot waive his fundamental rights. The very last portion of Article 13 is Clause 3, which gives us the term law and laws in force. The term law, just like the term state under Article 12, has been given a very wide connotation so as to ensure that fundamental rights are not infringed by the state or by its legislative and executive bodies, including their agencies and instrumentalities. Here, the term law includes any ordinance, order, bylaw, rule, regulation, notification, custom, or usage having the force of law. There's not only legislative enactment, but anything mentioned here can be challenged as infringing a fundamental right. The second term is laws in force. The expression laws in force in Article 13, Clause 3, Subclause B, refers to the laws passed by the British Parliament before independence and are still applicable in India. Any of those laws which were brought in force by the British government and are still operative, if found not parallel to a fundamental right, shall be declared void ab initio. An example is the Fugitive Offenders Act, which was enacted in 1881. Amendments made under Article 368. In the case of Golak Nath versus State of Punjab 1967, the Supreme Court held that the term law in Article 13 included an amendment of the Constitution passed under Article 368. However, by the Constitutional 24th Amendment Act 1971, inserted Clause 4 in Article 13 and Clause 3 in Article 369 to the effect, nothing in Article 13 shall apply to any amendment of this Constitution made under Article 368. The constitutionality of this amendment was upheld by the Supreme Court in Keshav Nanda Bharati versus State of Kerala 1973. It follows that the term law in Article 13 excludes amendment of the Constitution made under Article 368. With this, we come to an end. I hope this video was helpful in providing a simple and clear understanding of Article 13, laws inconsistent with fundamental rights. For any further queries, please drop your questions in the comment box below and don't forget to like, share and subscribe. Thank you.